All right. All right. Good morning, everyone. Welcome back to another NGSBA webinar. My name is Michael Quedal, Associate Director of Marketing for the New Jersey School Boards Association. And thank you so much for joining us today as we talk about today's topic, what's brewing in education law, Coffee Talk with Kathy and Caitlin. We're also simulcast on our YouTube channel. So welcome everyone who's in the live room right now on our Conference SWUGO webinar site, and welcome everyone on who's joining us through YouTube. So today, what's brewing in education law? Can't wait until NGSBA's next training session or conference. You are in luck. Join us today for a brand new webinar series. Members of our NGSBA legal team will provide a timely overview of the most recent legal decisions posted by the Acting Commissioner of Education and the School Ethics Commission concerning education law. If you're interested, and I know you all are, you're here this morning, in learning about the latest developments in education law, grab a cup of coffee, kick back and relax, and join us this morning as we informally discuss the facts from the most relevant cases, the determinations rendered, and how those decisions may implicate the service of board members and/or administrators. This presentation, because you are here this morning joining us live, and because I know everyone plans on staying for the entirety of the webinar, this webinar does offer one BMA Board Member Academy credit for all those, like I said, who are here live this morning, joining us and stay for the entirety of the presentation. Couple things regarding the Zoom features really quickly before we get going here. Towards the right side of your buttons, you will see the CC button. That is your closed captioning functionality. If you click that, it will allow you to view the closed captioning of this session. You will also be able to view and save the entire transcript of this webinar if you need it. Towards the end of the presentation, our presenters will have a contact slide with their information. We encourage any and all questions throughout this presentation should be directed to their emails, or you can always contact NGSBA's Attorney of the Day, your membership, one of the many membership benefits. Finally, today's session is being recorded and will be available through NGSBA's webinar conference site. So through SWUGO, you'll see, give us about a business day to upload the presentation recording and also the webinar slides onto that conference site. And please give us about a business day or two to have the BMA credit reflected on your transcript. So without further ado, it is now my pleasure to introduce Kathy Whalen and Caitlin Pletcher, legal counsel for the New Jersey School Boards Association. Good morning to you both.
Thank you, Michael. Good morning, everyone. Welcome to the first episode of What's Brewing in Education Law, Coffee Talk with Kathy and Caitlin. My name is Kathy Whalen. I serve as legal counsel and HR for NJSBA.
And my name is Caitlin Pletcher, and I serve as legal counsel in the Legal and Labor Relations Department.
So a little brief history. Caitlin and I have been work colleagues and friends for over a decade. We actually started working together about 10 years ago at a law firm in South Jersey, where we both represented boards of education throughout the state of New Jersey. We then both transitioned to roles at the New Jersey Department of Education. I then transitioned to a new role here at school boards. After a brief stint in private practice, Caitlin also joined us here at New Jersey School Boards, and we're so happy to be back together again. So part of our role here at New Jersey School Boards is to provide legal information and guidance to our members. And a lot of the information that we get from the Department of Education, we include in school board notes articles. However, Caitlin and I wanted to try to turnkey that information in a new medium for our members. Hence, Coffee Talk was born. So that's what we're here to do today, and hopefully in future episodes, to discuss with you new cases that have come out from the Department of Education.
And just very briefly about the format for our webinar, we are going to be taking turns summarizing cases, and then we will also build in questions to each other to really help to nail down the takeaways for these cases. You may have additional questions. As Mike mentioned earlier, our email addresses will be at the end of the presentation, and we encourage you to send any questions you may have to those email addresses, and we will get back to you through email.
And as always, with all of our presentations, a quick disclaimer, Everything that were provided to you today is informational only and should not be construed as legal advice. If you have specific questions regarding very specific facts and circumstances to which you would like a legal opinion, you will need to consult with your board counsel.
And just finally, one last housekeeping note, as Mike mentioned, the actual slides will be available on our webinar page through Swoogo. So in case you miss something, the slides themselves will also be available.
And with that, we are going to get started. So here's the disclaimer that we talked about, just reinforcing that what we're talking about today is only for informational purposes and is not to be construed as legal advice. So our first case that we're going to review comes from the Commissioner of Education, and it was decided on May 30th, 2024. In this case, J.H. was a 5th grade student, and he placed his hands in a female classmate's lap 2 times and touched her private area. Although J.H. initially did not recall his actions, he apologized after he watched a video of the incident. After the board confirmed the determination that his actions constituted HIB, his parents filed an appeal and argued that the findings should be removed from their son's student record because he did not fully understand or intend his conduct, as he suffers from disruptive mood dysregulation disorder and other disabilities. After the matter was transmitted to the Office of Administrative Law, an administrative law judge found that the conduct satisfied the statutory definition of HIB. The incident undeniably took place on school grounds, and it was recorded on a video camera that was actually in the school's hallway. The female victim could reasonably perceive the actions to be motivated by her gender. The victim reported being scared and uncomfortable because of the physical contact. The victim was reluctant to attend school the next day and requested to be excused from a group activity, and this clearly interfered with her rights and her education. And there was no doubt that a reasonable person should know that touching a student in their private area would result in emotional harm or insult, and that his actions, he apologized for his actions when he realized what had happened after watching the video. Because the board's determination had a rational basis and there was evidentiary support for the decision, the ALJ dismissed the petition of appeal that was filed by the parents, thereby affirming the Board of Education's decision that the conduct constituted HIB. The commissioner concurred with the administrative law judge that the board did not act arbitrarily, capriciously, or unreasonably, and finding that an act of HIB had been committed. And just a brief procedural note for those of you who may not be aware, when these kinds of cases are initially filed with the Office of Controversies and Disputes with the Department of Education, they are then transmitted to the Office of Administrative Law, and they are heard by an administrative law judge. The ALJ will issue an initial decision, and that decision is then sent back to the transmitting agency, which is the Department of Education, to issue a final decision.
Thanks, Kathy. So question for you. Do you think that the board's decision would have been upheld if they reached a contrary result? In other words, if they found that the conduct did not meet the definition of HIB?
So whenever the board makes a decision, the standard of review is always going to be the same. And that is there support for the decision? And was that decision arbitrary, capricious, or unreasonable? So if the board had said that the conduct did not constitute HIB, again, the reviewing court would have said, was that decision not finding HIB arbitrary, capricious, or unreasonable? Another important takeaway here for board members, is that in the intent of the perpetrator of HIB is not relevant in the board's decision as to whether or not conduct satisfies HIB.
Thank you. So for my first case, it's from the School Ethics Commission, which I will refer to as the SEC throughout the webinar. It's C-8723, which was adopted on June 17th, 2024. In this matter, the parents emailed the superintendent, copying all of the board members and requesting home instruction for their child in light of an upcoming medical surgery. According to the parents, the superintendent swiftly denied the request for home instruction, stating that the request did not meet the requirements of the law when you're making a request for home instruction. The parents claim that they followed up and the superintendent and the board members did not respond to them. They filed this complaint based on the board members' alleged non-response to their emails. The SEC determined that probable cause did not exist for the allegations that the board members violated 2 sections of the Code of Ethics for School Board Members when they failed to respond to the complainant's request for home instruction to be provided to their child. And because there was no probable cause, the SEC dismissed the complaint. As the SEC explained, based on the allegations that the complainant had set forth, that the proofs were not there. The one section of the Code of Ethics that the complainant had cited was a board member's obligation to uphold the rules, laws, and regulations of the State Board of Education, or to be in violation of a court order. And in order for that to be established, a complainant has to attach a final decision from a court of law or an administrative agency, and that was not presented with this case. So that was dismissed. The second section was a board member's obligation to make decisions that are in furtherance of the educational welfare of the children in the school district. And here the SEC explained that just because the parents didn't agree with the superintendent's decision to deny home instruction, that didn't mean that the denial was contrary to the educational welfare of their child.
So Caitlin, in discussing that case, you mentioned that the impetus for the filing of the complaint was that the board members failed to respond to the parents when they sent correspondence to the board. How do you think this case would have been different if a member of the board had actually responded to the parents?
Yeah, so it could have very well have been a violation, ironically, of the School Ethics Act if they had responded. And that's because by responding to the parents, it could have been considered an improper attempt to administer the schools. The home instruction regulations are very clear that it is the superintendent in consultation with the school physician to respond to home instruction requests. It's not the role of the board. So that could have been a violation if they had responded. It also could have been considered an improper attempt to resolve a complaint outside of a board meeting and prior to the resolution by the administration. So again, by not responding, the board members stayed in their lane and actually steered clear of those potential violations.
Yeah, so this case is a good reminder to board members that when you're contacted by a parent about a specific issue concerning their child, the best course of action is always to follow the chain of command and to refer the matter to the superintendent.
Exactly.
Okay, our next case is CO 420, which is actually a School Ethics Commission decision that was adopted last year. But we're going to discuss again because the Commissioner of Education actually issued a decision in May of this year related to this decision. So just going back to what I mentioned earlier about the procedural posture of cases, when the School Ethics Commission transmits a case to the Office of Administrative Law, again, an administrative law judge will issue an initial decision, and then that matter will be sent back to the School Ethics Commission. The School Ethics Commission can then adopt, modify, or reject the decision issued by the administrative law judge. If the School Ethics Commission finds a violation or recommends a penalty, that decision actually then goes to the Commissioner of Education to review if an appeal is filed. So that's why we're going to be revisiting this case again. So as a reminder, in CO 420, the respondent, after he lost his bid for re-election, he asked board counsel to conduct an investigation regarding the complainant, who was also a fellow board member, and to investigate her conduct in connection with the election that importantly he had just lost. The attorney bills evidence that over 30 hours were spent investigating complainant's conduct and cost the district over $5,000. As board president, respondent was one of the 3 people authorized to request services from board counsel. The finding was that the respondent violated 1224B, 24.1E, and 24.1F. Important language from the decision is as follows. Respondent and complainant had a substantial negative history and mutual disdain for each other. Respondent used his position as an individual authorized to contact the board attorney to direct the board attorney to conduct research regarding complainant's conduct. This was done to gain a personal advantage against complainant with whom he had a significant negative history. The School Ethics Commission also noted that while respondent argued he was authorized to seek services from the board attorney because the board policy authorized him to do so, the School Ethics Commission noted that his request was beyond the scope of his duties as it was motivated by his own personal animus for a political rival. The recommended penalty from the School Ethics Commission was a censure. So since this decision was appealed to the Commissioner of Education, a decision was issued in May of 2024. And following that appeal, the Commissioner of Education upheld the decision that the respondent violated multiple provisions of the School Ethics Act and also agreed that the penalty of censure was appropriate given the seriousness of respondent's actions.
So Kathy, does this decision mean that even if a board member is authorized by either the board policy or the board bylaw to seek legal services from the board attorney, that if they do so about a fellow board member, there could be a violation of the School Ethics Act?
So not necessarily. I think the important takeaway from this case, was the motivation of the board president in asking the solicitor to conduct legal research. And it was because the motivation was personal and had nothing to do with their duties and responsibilities, that it was that as the driving force for the decision that it was unethical conduct. I think if an authorized person to request legal services has genuine concerns about conduct of another board member, and that concern relates to their duties and responsibilities as a board president, then it wouldn't necessarily be unethical. But again, that's very fact specific and it would depend on the circumstances, but simply contacting board counsel would not necessarily be a violation unless there was, as in this case, personal animus or some, personal issue or vendetta that one board member had against another.
All right, our next case is C-8023, which was adopted by the SEC on June 17th, 2024. In this matter, the SEC dismissed most of the allegations as time barred. However, they did consider two of the allegations in substance. One was against a superintendent, and it was based upon her alleged actions that she took towards establishing an academy after the board allegedly indicated did not want to proceed with this academy. And the other allegation was related to a board member who had a scholarship award in her name. The SEC determined that there was no probable cause for either of the allegations and dismissed the complaint. In doing so, they went through the elements of the sections of the School Ethics Act that had been raised and just found that there were no proofs to establish these allegations. For the superintendent, the section of the act that was raised was when a school official either is undertaking an employment or service for compensation or not, that could be perceived as affecting the independence of judgment in the carrying out of official duties. And here, there was no facts pled about what that other service or employment was. She was just a superintendent. So that was dismissed based on lack of proof. The other allegation against a board member was based upon this scholarship being awarded in her name. And that, according to the complainant, was an attempt to use her official position to, gain some sort of unwarranted privilege or benefit for herself and her family. But when the SEC looked at it, they said, there were no facts that the board member had any role in establishing this scholarship award, in determining who would receive the award. And there also was no proof of what benefit she would have received or her family would have received by just having this award in her name. So based again on those lack of proofs, those allegations were also dismissed.
So in discussing this case, you talked about some of the claims being dismissed as untimely. Can you talk a little bit more about the time frame within which complaints have to be filed and if there is any discretion that the School Ethics Commission may have in deciding timeliness?
Sure. So under the School Ethics Act, the statute of limitation is 180 days from notice of the facts that form the basis for the alleged violation. And that is in contrast to typical school law cases that are brought through controversy and disputes with the 90-day timeline. And here, notice means either when the complainant knew about it or when a reasonable person should have known about the incident because it was made public. So in this case, the SEC explained that all of the allegations were related to events that took place at either a public board meeting, a public community event, or an open house. So here, the complainant should have known when they occurred in real time and had plenty of time to file this on a timely basis. An example of when that might not be the case is if, for example, there is some sort of incident or conversation in executive session, and that information cannot always be disclosed to the public immediately. So it's likely that the 180-day timeline would not start as of the date of that meeting, but when that information or incident actually became public is when that timeline would start.
Okay, great, thanks. CO321. So in this case, the respondent was the president of the Monroe Township Middle School Parent Staff Association, which I'll refer to as the PSA, and he was an active member of the PSA for several years before he was elected to the board. He also owns and operates Dot Designing, which made spiritware for the PSA. His company, to my understanding, based on the reading of this decision, was not solely created to provide spiritware for the PSA. He had other clients and customers, but the facts in this case relate to the spiritware sale to the PSA. So both before and after he joined the board, Dot Designing sold the spiritware to middle school students as a fundraiser for the PSA. And in order to promote fundraising sales, the respondent sent advertisements to the middle school principal using his business email address, and the school then sent that information home with students or would send emails to parents on a regular basis. So a complaint was filed with the School Ethics Commission alleging that the respondent violated several provisions of the School Ethics Act because his company was transacting business in the district, and he was requesting that the middle school principal send out communications to district families. Again, and that communication involved his personal business that was unrelated to his duties as a board member. So once the matter was transmitted, the ALJ issued an initial decision and actually found that there were no violations of the School Ethics Act and of the provisions that are cited here, and dismissed the complaint. Again, going back to the procedural posture of how cases work, once the ALJ issues an initial decision, it goes back to the transmitting agency, which again, in this case is the School Ethics Commission, and they can adopt, modify, or reject the findings of fact or the legal conclusions. And in this case, although the SEC agreed that the respondent did not violate 24.1F or 24B, the decision of the ALJ was modified to find that the respondent actually violated 1224A and 24C. Regarding the violation of 1224A, while respondent's ownership interest in his company was not a per se conflict, meaning that simply owning the business was not a conflict in and of itself, the transaction of selling his company's merchandise on behalf of the PSA directly to district students and parents through his website and picked up at his company's location was in substantial conflict with the proper discharge of his duties as a board member, even if the merchandise was donated. Respondent's conflict was further compounded by the fact that he used the middle school principal to send out messages, and he, as a voting member of the board, oversees the employment of the middle school principal. Regarding the violation of 1224C, the School Ethics Commission found that respondent and the company he owns have an indirect financial involvement in the principal's employment in the district because the respondent contacts the principal on a regular basis to request that the principal send emails to students and families to promote the sale of the spiritware. And in this way, it's free advertising that garners name recognition and goodwill for his company. Based on the violations, the School Ethics Commission recommended a penalty of reprimand. Another important note here is that this decision was just adopted by the School Ethics Commission on June 17th. And we do not know as of today's date, which I think is July 17th, whether or not this decision has been appealed to the Commissioner of Education. So if it is appealed to the Commissioner of Education, we will likely revisit this case again in the future to see how the Commissioner ruled, whether or not the Commissioner agreed there was a finding of a violation or the recommended penalty.
So Kathy, what could the board member have done here to have avoided being found in violation of the School Ethics Act?
So I think anytime a board member has a business that does business in the district, or if they want to do business in the district, the most important thing that they can do is, before continuing to do that, even if they did that before becoming an elected member of the board, is to request an advisory opinion from the School Ethics Commission. So what a board member can do, or any school official, they can request that the SEC advise whether very clear and specific conduct that has not yet happened would violate a provision of the School Ethics Act. And then they can rely on that advice in doing or not doing something moving forward. The decisions from the School Ethics Commission, there are advisory opinions that are public that can be reviewed. And between those public advisory opinions and the decisions issued by the School Ethics Commission, it's pretty clear that if you have a business, your business and your customers and clients should not be directly solicited from the school district when you serve on the Board of Education.
So if you're not sure, ask. And the nice thing about the public advisory opinions is that they are separated by topics.
Yes.
So that does help in navigating what already might be out there to help.
And if you have a question about which advisory opinions may be germane to a specific question or issue you have, you can always contact the School Ethics Commission and ask for those advisory opinions, which may be responsive if it's not clear when you're on their website.
That's a great tip. All right. My next case is C-2222, which was adopted on June 17th, 2024. This case is mostly about social media and disclaimers. And there were three specific events that led to this complaint, where it was claimed that this board member was trying to attempt to use her official position to get advantages for herself and others. So the three events were: one, she endorsed certain candidates for the board on her social media account. It was a post that was on election day. She also changed her Facebook profile picture to an icon that endorsed certain candidates for the board. And the last event was that she authored and published an op-ed about the board. For the two social media events, the post and the profile picture change that endorsed candidates, there was no specific disclaimer that accompanied each individual social media action. There was only a general statement in her about section of her personal Facebook page that her opinions were of her own. So important to keep in mind here, there was no specific disclaimer for either of those specific posts on Facebook. So this case, as Kathy explained, goes to the Office of Administrative Law. And here, the Administrative Law judge did find that there was a violation of the School Ethics Act for that social media post that she posted on election day to endorse certain candidates. And that post contained language saying, "People have been asking me who will help me on the school board. I believe that candidate A and candidate B are the two truly independent candidates. I ask that you use your votes for these two only. I have honestly never seen a candidate put this much time and effort to get to know all the ins and outs of the district. And finally, candidate B is not afraid to stand up for what he believes in, even if it is not the popular thing to do. I appreciate that." So that was the post that led to the violation, according to the administrative law judge. And the administrative law judge explained that in this post, the board member more than mentioned her board member status, and she directly responded to the question of who will help her on the board, and then continued to urge voters to select her preferred candidates over the incumbent. So the ALJ said, because of all of that and mentioning her board member status, at a minimum, the post required a disclaimer because it could be perceived by the public as a board endorsement, not an individual personal endorsement. So because of those circumstances, the ALJ determined that, again, it was a violation and recommended a penalty of reprimand. The matter goes to the School Ethics Commission, and they disagreed. They said that the election day post did not violate the School Ethics Act, and they dismissed the complaint. And they agreed that they acknowledged that, yes, it does imply from the post that she is a board member. However, the School Ethics Commission focused more on the content of the actual post and the language that indicated the post is her opinion. I believe, I ask, I have honestly never seen a candidate. I appreciate that. So the SEC explained that when you view the entire post, a reasonable member of the public would find it clear from the context and overall tone of the post that she is expressing her opinion of the candidates that she supports and is speaking in her individual capacity and not on behalf of the board.
So social media cases are a hot topic right
Mhm.
now. So even though the ALJ said it was a violation and the School Ethics Commission disagreed, do you think that that if the respondent had used a disclaimer on the election day post or the endorsement post, that would have made a difference, at least in the mind of the administrative law judge?
Yeah, I mean, I think that it would have helped in the mind of the administrative law judge, but I also think that it is important to keep in mind that, disclaimers are not foolproof. They certainly help to lay that groundwork that, hey, from the start, please be advised that I am speaking in my individual capacity, not as a board member and not on behalf of the board. It puts it all right out there. However, if you continue in your post to use words like we, our, when referring to board matters, it still could be perceived that you are speaking on behalf of the board, even though you have that disclaimer. And actually, in one of the cases that the SEC mentioned in this matter in rendering its decision, they talk about a board member who had used a partial disclaimer that the opinions were of his own, but he proceeded to use that plural, we, our language. And therefore, it was perceived that he was speaking on behalf of the board when he was endorsing certain candidates and then speaking against another candidate. So, again, disclaimers are always great, but also be mindful of what you continue to write after the disclaimer.
So the disclaimer could have helped.
Yes.
Maybe. Maybe.
Our favorite answer, it
Yeah.
depends. It could have, but there's more to it than just a disclaimer.
Yeah, and the important part here too is also that the School Ethics Commission didn't look at the presence or the absence of a disclaimer as dispositive. It was actually the substance of the speech that was the driving force for its decision. And I think that's important for board members to remember that, in even administrators, the presence or absence is not going to win the day. It's really what you're saying and whether or not there is that nexus between your status as a board member and the content of the post.
Exactly.
Okay, C4523. So following what he regarded as personal attacks from the complainant at public board meetings, the respondent contacted the building principal where the complainant worked. So this person was not a district employee. During a conversation with the complainant's workplace supervisor, the respondent identified himself as a board member, claimed that complainant attacked him with unfounded claims, indicated he was preparing to sue the complainant, and expressed the belief that complainant's attacks were due to his opposition to gender-neutral bathrooms. So in simple terms, essentially, following a board meeting, a board member reached out to the supervisor of a person who offered public comment at a board meeting that the board member perceived as being a personal attack. So based on this conduct, the complainant filed a complaint alleging that respondent violated 24.1E because he was trying to silence her from speaking out at board meetings and because he identified himself as a school board member in a private matter for his own perceived personal gain. So going back a little bit on procedural issues here, when a complaint is filed with the School Ethics Commission, and this is effective with the new regulations that were adopted by the SEC last year, the respondent can file a written statement. There's no longer the ability to file a motion to dismiss, just a written statement, and the written statement itself can also ask for the matter to be dismissed because of insufficient factual information or evidence. But when a respondent is served with an ethics complaint, it is imperative, even if a board member believes that the substance of the claims have absolutely no merit at all, to respond to that complaint. So in this case, the respondent did not respond to the complaint. And so when that happens, the SEC has the authority to decide a matter summarily, meaning to accept everything that the complainant is saying in the complaint as true and as an admission, as if that is exactly what happened. So in this case, the SEC said the respondent acted beyond the scope of his duties as a board member when he called complainant supervisor, represented himself as a member of the board, and complained about actions that she took as a private citizen at a board meeting. Respondent's behavior had the potential to compromise the board as it undermines the integrity of the board for its members to attempt to silence members of the public and or to encourage them not to attend future board meetings by calling their employers in an apparent attempt to get them in trouble at work. The recommended penalty for this violation was a censure, and the SEC also noted, regardless of whether respondent believed that he was being attacked by the complainant at a board meeting, he acted inappropriately by contacting a constituent supervisor regarding action taken in a personal capacity at a board meeting and which had no bearing on her employment at all. And again, in that case, we still do not know if the respondent will now file an appeal of that decision, will now ask for the matter to be sent back to the SEC or for a transmitted to the OAL for a hearing, or if there's some reasonable explanation for the non-response. But that is the decision and the outcome as we sit here today, and what happens in the future, we'll wait and see.
So as we wait and see, thinking about this situation, you know, we've sat at those board meetings and they get very contentious. What can a board member do if, you know, they're feeling attacked to address that?
Yeah, it's a very uncomfortable situation, and we have said this many times at many trainings and many presentations. You know, sometimes being a board member is a very thankless job, and sometimes board members have to sit at board meetings and endure these kinds of comments and feedback, which we feel are unwarranted and unnecessary. So if there's ever a time when board members are aware that there's going to be a contentious meeting, there's no harm ever in speaking with the board president, with the superintendent, or with the board solicitor about potential concerns that could happen. All boards of education have bylaws on how public comment will take place. And most of those bylaws typically say that obscene or inappropriate or derogatory language is prohibited. And it wouldn't hurt for that kind of messaging to be reinforced to members of the public, so that they know what is and what is not permissible during public comment. But as we both know, even if that cautionary message is delivered, there really is, unfortunately, nothing that can be done to stop a member of the public from expressing their opinion on a matter related to the board. And there are only very limited circumstances where that kind of speech could be actionable if it violates some kind of law or a policy or a regulation. And again, it's just one of those uncomfortable things that board members, like everybody else, need to unfortunately endure. But reinforcing what is appropriate at the start of public comment, reading the bylaws, and ensuring that we are making sure that people are following what is permissible during public comment can help. But clearly the important takeaway here is no matter how offended you may be by something that is said by a member of the public, you can't call their boss and complain about them.
Got it.
Check.
All right, and for our last case on our first episode, C-8823, which was adopted by the SEC on June 17th, 2024. This complaint contained 11 counts, 7 of which were related to the board member's social media posts. This board member also happened to be a member of the Joint Land Use Board for the township, which is a politically appointed position. And some of his social media posts at hand and the allegations in the complaint were related to his political affiliation. For example, some of his posts endorsed candidates, announced his receipt of an award at a political fundraising event, and reposted a link from the mayor. These posts really were just posted without anything else, any commentary. So those were not issues. And in looking at all of the posts, the School Ethics Commission explained that they had to look at each one individually because his social media page, it was personal. It was not a campaign or a board member page. So they had to look at each post individually to evaluate the content and determine if there is a nexus between the post and respondent's role as a board member, and whether a reasonable person would perceive the speech as being offered in an official capacity and pursuant to his official duties. And even if all of those things are there, the next question is, was it a violation of the School Ethics Act? So in this situation, of those 7 social media posts, there was only one post that had a nexus between the respondent's social media post and his board membership, and a reasonable member of the public may have perceived that he was speaking in his official capacity. And that post read, I look forward to continuing to work with you to reduce the bloated Board of Education budget as we help the 50% of our students who are failing the New Jersey State Standardized Test to pass them. That was the post where there was a nexus to his role as a board member that could be perceived as being made in his official capacity. So the next question is, well, was it a violation of any of the sections of the School Ethics Act? And the determination was no. Although there was a nexus, there were insufficient facts and circumstances pled in the complaint to determine that a violation had occurred. And as the SEC explained, a statement that's about reducing the budget and helping students to pass standardized tests, it's not a decision at all, nor was it contrary to the educational welfare of children or obstructing the programs and policies designed to meet the individual needs of all children. So because those elements were not established, that the allegation with respect to section B of the Code of Ethics for School Board Members was dismissed. The other section was also dismissed because the content of the speech was a general statement about helping students to pass standardized tests and reduce the budget. It did not have the potential to compromise the board. So because it was such a general statement, could not compromise the board, that allegation was also dismissed.
So just a point of clarification on this. So there's a lot of talk in social media cases about, is there a nexus? Is it in an official capacity? And I think what we need to make clear is that that first step really is a determination of, do we even need to look at the provision of the School Ethics Act, and is there factual evidence to support a violation? If you can't get past that first step of, is there a nexus, then the provisions of the School Ethics Act don't apply because your speech is offered in a personal or private capacity. Even if there is a nexus so that the School Ethics Act is implicated, a complainant still needs to provide enough factual evidence that there is a violation. So simply speaking in an official capacity by itself does not mean it's a violation. There still needs to be sufficient evidence presented to support a violation. But in thinking about this case, and it's the middle of July and November is going to be here before we know it. And on this hot day, we could definitely use a little fall weather. But do you have any information or guidance you can share with board members, given that, they may want to make some kind of political endorsement in support of a particular candidate, whether a local on a national level? What would you recommend, or what kind of information or guidance, not legal advice, might you provide to members?
Yeah, so again, as a reminder, this is not legal advice. This is, all cases, and especially school ethics cases, are very fact sensitive. So if you are thinking about making a specific post or endorsement, please consult with your board attorney about what that post may look like, just to be as safe as possible. All that being said, there is no prohibition against a board member to express a personal opinion about who they think is the best candidate at the local or national level. You certainly can do that. However, the SEC has issued some guidelines through their decisions that help you do it in a way that it keeps you not crossing over to the ethical violation area. And some of those guidelines are, one, we've talked about today, disclaimers. Be sure to include a very clear disclaimer that you are making this endorsement in your individual capacity, not as a board member and not on behalf of the board. And that goes for whatever medium that this endorsement is in, whether it's a social media post, a flyer, an article in the newspaper, whatever it may be, that disclaimer should be very, very loud and clear. In addition to that disclaimer, as we've also discussed today, don't just put that and then continue to write as if you were writing on behalf of the entire board. Do not use words like we and our, or anything that could give the perception that you are speaking on behalf of the entire board. And to that end, that also means not including information that maybe you only know because you are a board member, or that is confidential, or that, again, detaching yourself as much as possible from including any information that could form that nexus to your role as a board member and your official capacity. So with all of that in mind, any slight deviation from those guidelines from the School Ethics Commission could change the analysis and put you, towards the ethical violation line. So really just as, again, another disclaimer that those parameters are out there, but any deviation from them could change a determination by the SEC. And finally, even if you follow all of them perfectly, that doesn't stop anybody can file anything. So somebody could still file a complaint against you. So, the question becomes, we've heard about some of the procedural pieces of this process where, yes, you may be able to submit a written statement right away and hope that the complaint gets dismissed because you did everything appropriately. However, do you want that headache? Do you even want to have to file a written statement and have this lingering over your head? And if you do not want to deal with the headache, the safest is always just to not post anything.
Yeah, I think it's again, a good reminder that no matter your best intention, you follow all the rules, you do everything that you are supposed to do. You read all the decisions, you read all the advisory opinions, and a complaint can still be filed.
Mm-hmm.
So you just need to be mindful of, the risk, the cost benefit analysis for those kinds of decisions. I think that's really important for people to remember. We're not telling you to use social media any kind of way or not use social media any kind of way, but really consider again, the costs and the benefits of posting that kind of information. And that could depend a lot in part on, your community. The people who live there, who's looking at your social media page, how often they're there and what they're saying in response and how often they're watching every little word you say. So those are things that you need to consider.
Great.
So that's it for today. Caitlin and I are just so excited to be able to provide this kind of training and webinar and presentation to you. Our goal is to do this on a reoccurring basis. If there's anything that we've done today that you would like, to suggest a recommendation or other ways that we could provide this information in a way that would be more helpful or meaningful, please feel free to email us. I think Caitlin's going to go over how you do that, but our contact information is listed here. Our preference is that you send the information or a question or a concern to the attorney of the day email address so that she and I can tag team how we're going to respond to those questions, because we do appreciate your feedback.
Yes. Yeah. So here we have on our last slide here, all of our contact information in the legal department, as well as the attorney of the day email address. And also through our NJSBA marketing, future dates for this series will be announced very soon. And we do look forward to seeing all of you again and continuing to, on our end, just keep up to date with all of the recent decisions that are released by the acting commissioner and the School Ethics Commission, so that we can keep you up to date in this type of a format, which we hope that you have enjoyed today.
And before we turn it back over to Mike,
yes.
I'll just announce that our next webinar is in theory going to be scheduled at a time where Caitlin will be on a leave of absence because she is happily expecting baby number 2. I am going to find a fill-in for her, so we will be able to continue the series.
Yes, thank you.
So congratulations to you and your family.
Thank you. Thank you. Yes, I will miss all of you at our next summit, but hopefully we'll see you all soon. And with that, I will hand it back to Mike for some concluding remarks.
Awesome. Thank you both so much. A fabulous presentation. We are so excited about this Coffee Talk series. And yes, to reiterate what Kathy said, congratulations, Caitlin. You will definitely be missed on your leave, but time flies, especially when you have 2 of them, right? So you'll be back sooner than you know. I want to thank you both again for a great presentation. All those who are attending live today, if you have a question or any sort of feedback or anything, don't hesitate to reach out to any of those on the contact information sheet. And of course, the attorney of the day. It gives our legal team a little bit of room to organize the questions coming in. So we definitely encourage you to utilize your membership benefits and utilize our attorney of the day. I'm definitely biased, but I truly believe that I genuinely believe that our legal team is the best out there. So if you have any sort of question or anything regarding your district, between our folks in our legal department, these professionals, they will get your question answered. They're professional, they're prompt, and they're just a great group and incredibly knowledgeable. Obviously, if you're looking for legal advice, definitely consult your board attorney. But if you're looking for something, information regarding anything that we went over here today, or legal information regarding policy, definitely reach out to us. Reach out to this team, not me. Definitely not me. This team, and they'll get your question answered. So, again, everyone that has attended here today will receive one Board Member Academy credit. Give us about a business day for those credits to be reflected onto your transcript. This webinar is being recorded and also simulcast on YouTube. So you can obviously log in to SWOGO and see this webinar recording along with the presentation slides, or you can visit us, our YouTube page, youtube.com/NGSBA, to view the recording. So we encourage you to share that with other team members and members in your district. So definitely visit us at ngsba.org. Under the trainings tab, click webinars. That you'll see all of our previous webinars we've had in the past, and a ton of great content upcoming, including obviously this series, which will be posted in a couple more weeks, looking forward into the fall. So again, I want to thank quick shout out again to Kathy and Caitlin for a great presentation. Thank you for joining us today live. If you're watching this on recording, thank you as well. And I hope everyone has a great rest of their week. And we will definitely see